Fifth District of the State of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge, presiding. All persons having visited before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay. Good morning. Welcome to a session of oral argument of the 5th DCA, as indicated by that's our marshal, Charlie Crawford. Oh, there he is. He's still here. He actually stuck around here. What do you know? As the marshal indicated, I'm Judge Lambert. I'll preside today. We have one case. Seated at the panel to my right is Judge Eric Eisnagel. To my left is Judge Molly Nardella. We have one case, 21-2933, John Rhodes Industrial Park, LLC, v. Century View Systems, Inc. We have the unusual circumstance, I guess, our appellant. I assume you're Mr. How do you say your last name, sir?
Mr. Sobchak.
Mr. Sobchak. I guess your opponent, Mr. Menokal. I apologize if I'm mispronouncing that. You can have a seat, sir. Thank you. He is not here, and our efforts, or the marshal's efforts to actually find out where he might be in case something happened to him, I guess he's not here and he's not on his way.
I can very briefly address that because I called his office and sent an email. I spoke to somebody at his office who told me that he didn't receive notice and he wasn't aware that there was an oral argument. I have not spoken to him. I emailed him and gave him my cell. But I haven't heard back yet.
Well, that's
in that
not.
case, maybe we shouldn't.
I don't know how to speak to the notice. I mean, I got it. I don't know.
Can we find out that he actually didn't? Don't they?
I'll re-verify, Chief. The clerk's office telling me he acknowledged receipt of notice, but
Yeah, go ahead and do that. So, I mean, if. So I guess before today, you haven't had any communication with him, like negotiations or anything like that, or?
Certainly no negotiation. He recently filed multiple times motions for attorney's fees, and so he emailed me a couple times, but I haven't spoken to him about oral argument.
Well, I mean, if he truly didn't get noticed, that's one thing, but that's kind of the thing we asked our marshal, saying, well, did we send it to the wrong place? And the clerk's office seems to believe that he signed off and acknowledged the email, so, because they're all sent by email now, so if that's the case, then we're here and everybody's here and he just he's not, and we'll proceed. I mean, we'll proceed in the sense that if we are going to go, because you have a cross appeal, I mean, obviously he, as the appellant, he's the burden, and, you know, so if you choose to want to argue your cross appeal, well, that's certainly your prerogative to do or not to do as you choose. You have the time, because, I mean, I know you've taken the position in the brief that, well, if you guys affirm, then off we go, but if we don't affirm, you know, like what the trial judge did regarding the summary judgment. Uh-oh. And the winner of the Oscar is... Okie dokie. Looks like the notice of oral argument was sent to both of you simultaneously on May 25 at 10:57 and 49 seconds. And, well, you're pretty prompt. You acknowledged yours within a minute and a half. But, more to the point, Mr. Menokal acknowledged his about 30 minutes later. So, he got it. Okay, that being said, We're here, so we're ready to go, and we've not heard any more from their office about anything. Okay. All right, so counsel, you have 20 minutes to use as you deem appropriate there's nothing for you to respond to the appellant's argument as to why we should reverse the judgment. If you want to address the summary judgment that was entered against you, the interlocutory order on the rent abatement claim, you've got 20 minutes to use if you choose to.
Thank you. May it please the court. Tim Sobczak on behalf of the appellee cross-appellant CenturyView Systems. With me is Kirk Hall, the principal of CenturyView. I'll be happy to address the cross-appeal. I didn't plan on spending much time on it today, but I'll...
I know we're all in a unique scenario, but I don't want you or your client to feel you're like shortchanged, saying, well, okay, they're not here, they must be losing. You don't know that, until we decide, so I don't want you to say, well, I didn't make an argument and look at what those guys reversed the judgment anyways, and they affirmed the summary judgment, and I didn't have a chance to tell them why that summary judgment was wrong. So here's your chance to use as much or as little amount of time, and by me saying that, I'm not encouraging you to take one way or another. I'm just saying we're giving you your due process.
I appreciate that. So I'll start with the cross appeal, and I'll start with I guess the introduction and what Your Honor stated initially. We're only seeking a reversal of the summary judgment order to the extent this court reverses the dismissal order. Otherwise, everything is great for CenturyView. I'll talk about the three cases that I cited, which I think are very instructive on how to interpret paragraph 29, which of course is the paragraph that contains the rent abatement sentence and what John Rhodes believes to be an exclusive remedy. The cases that I cited, Coastal Computer, Marco Bay, and American University, I think are instructive because they dealt with, albeit different language, but very similar for our purposes. Languages in a contract that state a remedy, but not the remedy, which is what we have here. Paragraph 29 states, in summary fashion, CenturyView shall be entitled to abate rent.
So you think if that paragraph 29 says the parties agree that the exclusive remedy, if landlord does not substantially comply with paragraph 29, is the abatement of rent and return of the security deposit and nothing else? If it says something like that, then you'd be having a tougher road to climb or ladder.
Absolutely, and I think Florida law says that if it's going to be an exclusive remedy, and that's how the court is going to interpret it, it's got to have some exclusivity language in it. It's got to have something that makes it appear to be exclusive. And I think the Coastal Computer case discusses that in particular.
Counsel, if, let's say for the moment that the panel agrees with your cross appeal, and let's say the panel decides that it was not an exclusive remedy, that you were not foreclosed from asserting a breach, that's not the end of our analysis then, is it? I mean, don't we have to reach the additional issues of whether there was a breach to begin with?
It depends. If for purposes of evaluating the order on the motion for summary judgment.
No, I mean evaluating the entire case. I mean, at some point, like if you had prevailed on, let's put it this way: if you had prevailed on your motion, if it's not the exclusive remedy, is the case over? Let's put it that way.
The case is still over because we won at trial.
No. Rewind. None of that's happened. Okay? If it's not your exclusive, if it's not your exclusive remedy, do you still have to go to trial?
Arguably, yes, because the summary judgment order was addressing what I believe.
You still have to prove a breach, right?
Correct.
Yeah. So, I mean, and I guess my point is, while maybe an important issue, it's not the end of the analysis entirely.
Correct.
Okay.
The summary judgment hearing was addressing a legal interpretation, and that's it. Subsequently, we obviously did go to trial, and I believe,
You prevailed on essentially a different ground or a different theory, right?
correct.
Yeah.
I would argue that we also prevailed on proving that there was a material breach, and Century was entitled to terminate 100 days into the lease, 27% of the lease term gone. And
If the trial judge had not entered the order that you're unhappy about, then you would have had your turn to present your case
that's correct.
and then presented, here's my damage over and above, they've got my rent and they've got the security deposit, we like that back, but over and above that, we had this contract that we're going to provide services to, I guess, the federal government or somebody, and we lost money because we couldn't get in and operate, but that became kind of, you didn't get to that point, well, A, because of what the judge did ahead of time, and B, you won.
Prevailed on involuntary dismissal.
Right, and I guess because of how the judge ruled, even if you would have prevailed on your motion for involuntary dismissal, if your other claim was still pending, you'd have said, well, thanks for that part, Judge. Here's my case in chief on my counterclaim, and I'd like damages over and above getting our money back.
Correct. The one point I'll make, in what I attempted to make in the answer brief, is that Century was not seeking damages over and above the return of the security deposit and its first month's rent. That was the damages that it was seeking.
That's what you were seeking in the counterclaim?
Correct. The wherefore clause of the counterclaim contains broad language, and it says I think damages to be proven at trial. But I think it was pretty clear through the litigation what we were seeking was.
Okay, well, I guess I'm then unclear then. So when the judge entered the summary judgment saying all you could ever get is the return of the money, then it really doesn't have, you didn't lose any damage claim other than the fact you said, well, if the lease is over because they breached it, I want to get my money back because I paid my first month rent and I didn't get in there and I paid a security deposit and I'd like that back.
I would disagree that the trial court's summary judgment order found that we would be able to get our security deposit and rent back.
Okay.
I think the tenor was pushing towards, you had one remedy, and that was abatement of rent. You didn't exercise that remedy, and you terminated, and so you were liable.
Oh, you forfeited that, so you were concerned that was okay, my $55,000 was gone.
Correct.
Oh, okay, all right.
That was the concern that we had going into the trial, to ensure that we were able to prove a case that we didn't in fact breach.
So we can't get in and use the thing, we'd like our money back. Because we can't get in because you guys haven't fixed it up according to paragraph 29 at least sufficiently.
The last point I'll make on the cross appeal is that the trial court made an error in finding that the broad scope of that exclusive remedy in paragraph 29 applied to the other breaches which are stated. And in the first affirmative defense of Century and Century's counterclaim, they argue not only did you fail to complete the 17 enumerated items in paragraph 29 of the lease, but you breached paragraph 61, 66, and 67 by failing to deliver the property with the particular mechanical and infrastructure that those required. And I think there's no reasonable interpretation of the sentence in paragraph 29 that would make that apply to those other paragraphs, because the sentence in 29 that discusses abatement of rent specifically says such work, and it's referring to the such work in paragraph 29. And the effect of the trial court's order was to find in favor of John Rhodes on liability in its entirety, which was in effect to negate the ability of Century to prove a breach of those other paragraphs, which were important. So for that reason, at the very least, I think the trial court's order is in error on that point.
Okay.
Now, I know that the appellant's not here, but I do want to address a couple of items that were brought up in the reply brief, and then also I'd like to start with the notice of supplemental authority, because there's some important issues with that. Century's position is that the notice of supplemental authority, which provides the City of Melbourne Code and also the 2020 Florida Building Code to the court's attention, those items were never brought to the trial court's attention, and no witness specifically interpreted those codes in the manner that John Rhodes has argued in its
So you're
reply-
saying that's not proper supplemental authority, that would be some kind of evidence that would have had to have been presented?
That's correct.
I mean,
That's correct. And
Okay.
I'd also note that the 2020 building code is not the applicable code.
Is a code, county or city code, is that law or is that evidence?
I think it stretches into both. And the concern that Century has is that the interpretation that's stated in the reply brief by John Rhodes is not supported by someone saying that to the trial court. That's the biggest concern that I have, and I'll give an example. In the reply brief, page 2, John Rhodes says, the above referenced sections, and it's referring to section 105 of the building code, apply to John Rhodes' work under the lease. And what John Rhodes is attempting to argue is that there's exemptions in the building code that say you don't need to get a permit. You can start work on construction without a permit. No one has said those 17 enumerated items fall within that exemption. That would take a witness to interpret that, and no one did that.
So you're not suggesting that the code is evidence, but you're saying that the code by itself is not enough. You would also need some sort of expert testimony or specialized testimony to fill in the blank.
That is, yes.
Okay.
Mr. Owen, the engineer who presented evidence on behalf of John Rhodes discussing construction and various engineering issues, should have been the one to say that, and he didn't. And I'd also note that the other interpretations that are cited here, or the argument made by John Rhodes in the reply brief at page 2, which are simply not supported. Section 105 supports the City of Melbourne routinely certifies work after it is completed. That's not stated in the code, and no one stated that at trial.
Does our record reflect when the work actually was certified?
It doesn't, because it was never certified.
Okay. So I guess my question is, why does it matter that, let's assume for a moment that the city routinely does certify work after the fact? If it was never actually certified, why does it matter? Why does that matter in this case? In other words, it was never actually, if our record reflects it was never actually permitted after the fact or before, then how relevant would that evidence have been?
Because that was one of the primary issues.
No, I know, but this is kind of a softball to you, I think.
And I'll get there. And the issue is not only permitting, it's the approval and certificate of completion problem. At some point, that has to be proven for John Rhodes to prove its case that the property was suitable for occupancy and substantial completion had occurred. And they never proved that. Not as of the termination by Century, not as of the trial, which was a year later. At no point did they show that at some point you should have moved into the property because it was ready to go.
well, they didn't have any really, once you guys sent the letter of June 7th, they didn't have any reason to keep going forward, did they? Trying to fix the building?
Well, according to John Rhodes, it was already complete 2 months
Well, I know
before.
that, I mean, that was the rub. I mean, I think their position, I guess, at trial was, we've substantially complied with 29, and you said no, and you made your motion for involuntary dismissal, and the judge agreed with your argument and your written in your oral motion.
I think Century's position is that they would have to prove that. If they want to show that the property was suitable for occupancy and that it was ready for Century to take possession, they would have to show that, for example, the fire safety code issues that were contained in the answer and the counterclaim were resolved. It's not possible, and I think this is what the trial court struggled with and what came out in its oral pronouncement. It's not possible to, on the one hand, say it is substantially complete, but on the other hand, say we have not followed the building code, we haven't sought permits or had approvals or have a certificate of completion, and therefore it's suitable for occupancy.
So your position, so if on March 1, the road said, hey, we're good, we're all done, we've complied with paragraph 29, and your fellow over there, the guy who makes the decisions, came to the building and said, boy, looks good, we're ready to move in, but there was no CO or permit, you're saying your guys couldn't have moved in and, spent the year in the lease and off we go? I mean,
Well, I think in that context, arguably, Century could waive the right to do that. But if you look at paragraph 29, substantial completion requires that the work be done so that Century can conduct its permitted use, which is a defined term, and it can do so without, unreasonable interruption. Immediately below that, the work is required to conform to all codes and regulations. I think you have to look at those two together, and I think when you look at them together, you expect that substantial completion, at a bare minimum, would comply with the local code and allow Century to actually have lawful occupancy.
So, counsel, what if the day after your client declares breach, right? I mean, you'd been, I think, if I recall, couple 2-3 months into, or maybe more, I can't remember. How many months into the contract were you, into the lease?
It was about 100 days, so 27%.
Okay. So your client declares breach. What if suddenly appellant, says, oh my goodness, we're about, they've declared breach, let's get this done, and they bring out the city the next day, and the city just stamps it. It's all good the next day. What does that do to your legal argument, if anything? So you've already declared breach. You've waited 100 days or whatever. You finally declare breach, and then the next day, they get it signed. So it's all legal then?
Nothing, I believe, is the short answer, because I think at that point, Century was entitled to declare breach, both because it's a material breach. I mean, 27% of a one-year lease term is gone. I think by any standard, that's material. Secondly, there's a time is of the essence clause, which the case law actually reflects the right to immediately terminate in that context. So the fact that termination occurs and some sort of cure occurs a day later, it's too late. I think that's the case.
Counsel, I want to talk to you about Florida law and the requirement or not the requirement of having knowledge of the breach. So as I understand your claim is we didn't breach the contract because our performance was excused, right? Do you have to have knowledge that your performance is excused for the very reason that you won at trial, which is they were not performing according to the code that they were required to work under because they did not get a permit?
Do we have to have knowledge at the time of termination? I don't believe that was briefed, and I don't know that I have a clear answer on Florida law on that point. I do think, in this case, the record was clear that Century did have knowledge of code violations and problems with substantial completion and suitable occupancy. At trial, it was made very clear that in the lead up to termination, in March 2019, it was Century's attorney telling John Rhodes' attorney, you need to have a certificate of completion before we come in there. Mm-hmm. And Century's attorney, there's an email that is an exhibit at trial in which Century says, I've called the building department. You need to get that done. So there was knowledge of the problems. There was significant knowledge of the painting over of the sprinkler heads and the violation of the fire code. There was knowledge that at no point all the way up through termination had a building official come in and approved the fix to the sprinkler heads. Mr. Norica, who is the Archangel contractor, testified at trial that before they could move in, a building official would have to approve that. So I apologize, I'm not very clear on the law, but I believe that Century did have knowledge of the particular issue for which it terminated, before it terminated. With my last time here, I want to touch on what I think is the lowest hanging fruit. This is an involuntary dismissal, and so the standard is look at the light most favorable to the non-movement, to John Rhodes. And I think even in that light, I don't think they presented enough. And what they can point to solely is Mr. Owen's testimony that he has, in the past, certified work post facto. And that's been sufficient. And it's Century's position that that's not what they needed to do to win a trial. They can't show a theoretical compliance. They must show that they actually complied and that the property actually was ready for occupancy. Mr. Owen is incapable of doing that because he is not the building official. And on cross-examination, he acknowledged the building official is the one with discretion and authority to approve these things, not Mr. Owen, not the certified engineer. And that's critical because that means that John Rhodes needed a witness that it didn't have there. That's the only way it could have proven its prima facie case was through a document or a City of Melbourne official. That's why they sought to reopen evidence to bring in that exact type of witness. So I don't think they've met the prima facie standard. So with that, I will stop as I'm out of time. Thank you.
Okay, thank you. All right.
They finally spoke with him directly, and he, although he doesn't recall preceding, he was inquiring if he could call in or Zoom in. We explained that we don't, it's a live hearing, we don't have a Zoom capability or a calling capability here in the courtroom, so.
This happened in December, so I assume we'll get a motion for rehearing or something. All right, thanks a lot. All right, we'll stand adjourned. Thank you, counsel. Okay.